Contract means an agreement with specific terms between two or more persons or entities in which there is a promise to do something in return for a valuable benefit known as consideration. Since the law of contracts is at the heart of most business dealings, it is one of the 3 or 4 most significant areas of legal concern and can involve variations on circumstances and complexities. The existence of a contract requires finding the following factual elements: A. An offer. B. An acceptance of that offer which results in a meeting of the minds. C. A promise to perform. D. A valuable consideration, which can be a promise or payment in some form. E. A time or event when performance must be made, meet commitments. F. Terms and conditions for performance, including fulfilling promises. G. Performance, if the contract is unilateral. A unilateral contract is one in which there is a promise to pay or give other consideration in return for actual performance. A bilateral contract is one in which a promise is exchanged for a promise. Contracts can be either written or oral, but oral contracts are more difficult to prove, and in most jurisdictions, the time to sue on the contract is shorter, such as 2 years for oral compared to 4 years for written. In some cases, a contract can consist of several documents, such as a series of letters, orders, offers, and counteroffers. There are a variety of types of contracts: conditional, on an event occurring; joint and several, in which several parties make a joint promise to perform, but each is responsible; implied, in which the courts will determine there is a contract based on the circumstances. Parties can contract to supply all of another's requirements, buy all the products made, or enter into an option to renew a contract. The variations are almost limitless. Contracts for illegal purposes are not enforceable at law.